The HOA celebrated every new cabin they finished. They had no idea every nail they drove was making my legal case stronger. I stood in a Wyoming courtroom looking across at the people who had spent months turning my quiet island into a luxury resort. 30 cabins were finished. Millions of dollars had already changed hands. Everyone thought I had waited too long, until the judge looked up and quietly asked, "Who owns the shoreline?" That's when I reached for one old survey tube that changed the entire case. If you've ever wondered how an HOA could go that far, stay with me, because every step of what happened is real inside this story, and I promise the ending is worth the wait. And if you enjoy stories about ordinary people standing their ground with patience, evidence, and the law, consider subscribing so you won't miss the next one. The courtroom in Sheridan, Wyoming, was so quiet I could hear the ventilation system humming above the oak-paneled ceiling. Every bench was filled. Reporters crowded the back wall. Homeowners from Silver Pines sat shoulder to shoulder with contractors, bankers, and investors whose futures depended on what happened in the next few hours. Through the tall courtroom windows, I could see a sliver of Lake Redstone shimmering beneath the afternoon sun. Somewhere beyond that, water sat my family's island, 11 acres of pine trees, granite shoreline, and 30 brand-new luxury cabins that everyone in this room believed belonged to someone else.
Understood.
At the plaintiff's table, my attorney, Rachel Monroe, calmly arranged 3 legal pads into a perfect line before looking at me. "You ready?" she asked quietly. I nodded once. "I've been ready for 6 months." Across the aisle, Denise Holloway stood with the confidence of someone who believed the ending had already been written. Her tailored navy suit looked more like a politician's uniform than something worn by the president of a homeowners association. Beside her sat developer Logan Pierce, whispering to 2 attorneys while occasionally glancing toward me with a smirk that hadn't left his face all morning. They looked relaxed. Why wouldn't they? Their crews had already finished every cabin, every dock, every stone walkway, every luxury fire pit overlooking my shoreline. To anyone driving past the lake, the resort looked complete, successful, permanent, exactly as Denise had planned. Judge Harold Whitmore entered through the side door, and everyone rose. "Be seated." His voice carried the calm authority of someone who had spent decades watching people mistake confidence for truth. He adjusted his reading glasses and looked over the case file stacked nearly 4 inches thick. This matter concerns ownership of property commonly referred to as Redstone Island. His eyes moved toward Denise. "Counsel, you may proceed." Denise's lead attorney stood immediately. "Your Honor, this case should never have reached trial." He walked confidently toward the center of the courtroom. The plaintiff, Mr. Ethan Calloway, knowingly watched construction continue for months before filing suit. 30 cabins were completed. Millions of dollars were invested. Hundreds of families purchased reservations in good faith. He paused dramatically. If Mr. Calloway truly believed he owned the island, why wait until the project was nearly complete? Several jurors weren't present. It was a bench trial, but spectators nodded anyway. It sounded reasonable. That was Denise's greatest talent. She always made the unreasonable sound perfectly logical. The attorney continued. "Our clients relied entirely on county records, approved surveys, valid permits, and officially recorded property documents." He spread his hands toward me. "This lawsuit isn't about ownership anymore. It's about a man attempting to seize an entire resort after someone else assumed all the financial risk." Denise leaned back in her chair, folding her hands with a satisfied smile. She wanted everyone watching to believe I had set a trap, that I'd quietly waited for success before demanding ownership. Judge Whitmore remained expressionless. Then he looked toward Rachel. "Ms. Monroe?" Rachel stood. "Your Honor, every statement opposing counsel just made depends on one assumption." She glanced toward me. "That the defendants ever owned the shoreline they built upon." Silence settled across the room. The judge slowly removed his glasses. Mr. Calloway. Yes, Your Honor. You've heard the argument. I have. Before we spend several days hearing testimony, he leaned forward. I want you to answer one question. The courtroom became perfectly still. Even the reporters lowered their pens. Judge Whitmore spoke carefully. Who actually owns the shoreline? Every eye turned toward me. I didn't answer immediately. Instead, I reached beneath the counsel table and lifted an old brass-capped survey tube onto the polished wood. It wasn't expensive. It wasn't impressive. Its leather carrying strap was cracked from age. The brass ends had lost their shine decades ago, but my father had carried that same survey tube across the island long before anyone in Silver Pines had imagined building vacation homes there. I slowly unscrewed the cap. Several rolled documents rested inside. Original linen surveys, hand-drawn plats, weathered title records. The room watched every movement. Denise's confident smile faded for the first time all morning. Logan stopped whispering. Rachel remained perfectly still beside me. I looked directly at Judge Whitmore. Your Honor. I rested one hand on the survey tube. That's exactly why those cabins may already belong to me. The silence that followed felt heavier than any argument. No one moved. No one spoke. Even Denise seemed unsure whether she'd heard me correctly. The judge studied my face for several long seconds before glancing at the worn survey tube. Then he quietly said, I believe we'd better start at the beginning. I looked once through the courtroom window toward the distant blue water. 6 months earlier, the only things standing on that island had been pine trees, my late wife's fishing dock, and a weathered wooden sign carrying my family's name. So how had an HOA convinced an entire county that none of it belonged to me anymore? It started on a quiet Tuesday morning. I was repairing a section of split-rail fence along the road leading to the causeway when I heard diesel engines echo across the lake. At first, I assumed the county was grading the public access road. Then 3 white pickup trucks rolled past my gate, followed by 2 bulldozers hauling excavators on lowboy trailers. Every one of them turned toward my island. I climbed into my truck and reached the causeway just as workers began unloading equipment. Hold up, I called. A foreman wearing a bright orange vest looked at a clipboard before walking toward me. Can I help you? You can start by telling me why you're driving heavy equipment onto my property. He frowned. Sir, we're building Phase 1 of the Silver Pines Lakeside Retreat. Not here, you're not. Before he could answer, a black SUV stopped behind the construction convoy. Denise Holloway stepped out wearing sunglasses and carrying a leather portfolio. She smiled as though we were neighbors meeting over coffee. Good morning, Ethan. What exactly are you doing? Improving community property. I stared at her. This island isn't community property. It is now. She opened her portfolio and handed me several neatly bound documents. Across the top of the first page were the words, Property Boundary Revision. Attached behind it sat county maps, planning approvals, shoreline surveys, and recorded parcel transfers bearing official seals. Everything looked legitimate. I flipped through them twice. None of it made sense. My family has owned this island for 70 years. Denise shrugged. According to county records, your deed only covers the upland parcel west of the shoreline. That's impossible. It's recorded. She pointed toward the island. The shoreline and recreational parcel now belong to Silver Pines HOA. Workers restarted their engines. One bulldozer rolled past us. I stepped directly into its path. The operator immediately shut it down. No one crosses. Denise calmly reached for her phone. 10 minutes later, Deputy Aaron Blake arrived. He listened to both sides without interrupting. I handed him my driver's license and explained that the island had belonged to my family for generations. Denise presented the county file. Deputy Blake examined every page carefully. Finally, he looked at me. Mr. Calloway, these permits appear valid. They're wrong. They may be, but I'm not authorized to invalidate county records. So you're letting them onto my land? I'm saying ownership is now a civil matter. His words landed harder than I expected. The law wasn't protecting me. It was protecting paperwork. I watched as construction trucks crossed the causeway one after another. By noon, chainsaws echoed through the pines. By early afternoon, Rebecca's fishing dock, the dock we built together during our first summer on the island, lay broken beside the shoreline. The weathered wooden sign reading Callaway Island disappeared into a debris pile. By sunset, temporary orange fencing surrounded nearly half the island. The next morning, new signs stood where my family sign had been. Private property. Silver Pines. Authorized personnel only. Trespassers will be prosecuted. My own name had effectively been erased overnight. Friends urged me to block the road. Some suggested chaining the gate shut. One rancher even offered his tractor. I thanked every one of them. Then I said no. Because if those county records were fake, one reckless decision from me could become Denise's strongest piece of evidence. Instead, I drove to Sheridan and walked into the office of property attorney Rachel Monroe. She listened without interrupting while I spread every document Denise had handed me across her conference table. She studied the maps, the permits, the recorded transfers. Then she leaned back. They did their homework. You think they're right? I think someone worked very hard to make them look right. She tapped one survey with her pen. Starting today, Ethan, don't argue with them, don't threaten them, don't touch a single piece of equipment. What do I do? Rachel gathered every document into neat stacks. You build a better case than they built a fraud. As I left her office, my phone buzzed. A neighbor had sent me a photograph taken from across the lake. The first excavator had already started tearing into the shoreline. If the paperwork looked that convincing, who had created it in the first place? That question became my full-time job. The morning after meeting Rachel Monroe, I drove back to the lake before sunrise. Construction had already resumed. Concrete trucks lined the county road, while survey flags stretched across my shoreline as if someone had redrawn history overnight. I parked on public land across the water. Then I started documenting everything. Every truck license plate, every delivery receipt I could photograph, every contractor sign, every permit posted near the temporary gate, every time Denise claimed the island belonged to Silver Pines. Rachel had given me one instruction: assume every day ends in court. So every photograph carried a timestamp. Every conversation was written into a notebook before I went to bed. Every certified letter we mailed was copied twice. While they poured concrete, I collected evidence. Within 2 weeks, the island looked nothing like the place Rebecca and I had loved. The old fishing trail disappeared beneath fresh gravel. Ancient pines fell one after another. Concrete foundations spread across the ridge overlooking the lake. Denise held a press event beside the first completed cabin. Local newspapers called the project the future of luxury lake tourism. She smiled into television cameras. This development will create jobs, expand recreation, and increase property values for everyone. Then she looked directly toward my side of the lake. We're disappointed one individual continues trying to delay progress. By evening, my phone filled with anonymous messages. Quit fighting. You're just bitter. Stop wasting taxpayer money. Someone spray-painted trespasser across the entrance to my ranch gate. I photographed it before washing it away. Nothing was too small anymore. Everything became evidence. Rachel moved just as methodically. She filed requests for county planning records, tax histories, recorded easements, historic shoreline maps. Most arrived quickly. Some arrived with entire pages missing. Others contained handwritten corrections made years after the original filing. One afternoon, she called. "Something's wrong. What did you find?" "Not what I found. What I didn't." She slid several certified copies across her conference table when I arrived. "Your shoreline description changes 3 different times." I studied the legal descriptions. She was right. The acreage stayed the same. The wording didn't. One version referenced original survey monuments. Another referenced temporary construction markers. The newest version ignored both. Can they legally change that? They can. She paused. They just need authority. And if they didn't have it? Rachel looked me in the eye. Then someone manufactured authority. Construction accelerated anyway. Cabins 5 through 12 rose within weeks. Stone retaining walls wrapped around the shoreline. Private docks extended into water I'd paid taxes on for decades. Every improvement increased the project's value. Every improvement also increased the damages if ownership ever returned to me. Denise clearly believed time was on her side. She began filming me whenever I visited the public shoreline. One afternoon, she walked toward me holding her phone. "You enjoying watching us improve your view?" "I'm documenting construction." "No." She smiled. "You're documenting your own defeat." I didn't answer. That seemed to bother her more than an argument would have. "You could settle," she continued. "Take compensation. Walk away. My family doesn't sell stolen property." Her smile disappeared. Later that week, Rachel served certified notices to the construction company, the bank financing the project, Logan Pierce's development firm, and every major contractor. Each notice carried the same warning. Ownership remains disputed. Construction continues at your own legal risk. No one stopped building. Apparently, everyone trusted Denise more than the paperwork we questioned. Then something unexpected happened. An older contractor quietly approached me at a gas station. He looked around before speaking. "You didn't hear this from me." I waited. The survey crew argued the first week. About what? They kept saying one corner marker wasn't where the county map showed. What happened? The next morning, he hesitated. The marker was gone. Before I could ask another question, he climbed into his truck and drove away. That evening, I told Rachel everything. She immediately picked up the phone. "I know exactly who we need." "Who?" "The only surveyor I trust to tell us where the real boundary has always been." If the property lines had never actually moved, what else had someone removed before the construction ever began? Rachel answered that question the following morning. His name was Noah Whitaker. He arrived in an aging white pickup with a transit case strapped in the bed and introduced himself with a firm handshake. "Former Marine engineer," he said. "Licensed surveyor for 15 years. Rachel smiled. "And the most stubborn man I've ever hired. I take that as a compliment." Noah refused to look at the county maps first. "I don't want anyone else's opinion," he explained. "I want the land to tell me where the boundary is." That afternoon, we crossed the lake by boat and landed on public shoreline opposite the construction site. Since the HOA had fenced off the causeway, Noah began his survey from neighboring public property and adjoining parcels whose owners had given written permission. He unfolded faded copies of my grandfather's original survey while comparing them to satellite measurements. "The iron monuments should still exist," he said, "if nobody touched them." For 2 days, we searched through brush, rock outcroppings, and old fence lines. Late on the second afternoon, Noah stopped beside an enormous granite boulder overlooking the lake. He brushed away dirt with a small shovel. metal scraped against steel. There you are. A rusted iron survey monument emerged exactly where my family's deed placed it. He recorded GPS coordinates, photographed it, measured it twice. One original corner confirmed. The next morning, he found a second marker buried beneath decades of pine needles. By noon, he uncovered the third. Each one aligned perfectly with the original survey completed nearly 70 years earlier. Rachel spread the coordinates across the hood of her SUV. "They're consistent." "They're better than consistent," Noah replied. "They established the original shoreline exactly." I pointed toward the luxury cabins rising above the trees. "If those markers are right, they're building inside your property." The only remaining question was the fourth corner. According to every historical survey, it should have stood near the eastern shoreline where crews were pouring foundations for the resort's largest lakeside lodge. Instead, there was nothing. No iron monument, no broken concrete, not even disturbed soil. Noah frowned. "That's impossible." He measured again, checked old bearings, returned after lunch. Still nothing. Then he noticed something unusual. Fresh filled dirt, nearly 3 feet deeper than surrounding ground. This wasn't here long. Construction had buried the original surface. Noah requested permission to inspect the active work area. Denise refused before he finished speaking. "This is private HOA property." Rachel handed over a formal preservation notice. "We believe evidence relating to this litigation exists beneath your construction site." Denise glanced at the letter, then tore open the envelope, read one page, and smiled. "You should have come sooner." She walked away before Rachel could respond. The following morning, Noah returned with ground-penetrating equipment authorized from adjacent property. The scan revealed a narrow disturbance extending beneath the newly placed fill. Not natural. Something cylindrical had been pulled vertically from the ground. Exactly where the fourth monument should have stood, someone removed it, Noah said quietly. But when? That answer arrived unexpectedly. I had installed trail cameras years earlier to monitor wildlife crossing the causeway. Most had been taken down before construction, but one camera mounted high inside an old pine had survived unnoticed because its view overlooked the shoreline instead of the road. I rushed home and searched through months of archived memory cards. Hours later, I found it. Timestamp, 3 weeks before the first bulldozer arrived. The footage showed 2 pickup trucks parked near the eastern shoreline after sunset. 4 workers dug for nearly an hour. Then they lifted something long and heavy into the truck bed. Before leaving, one man shoveled fresh dirt into the hole. The camera couldn't capture faces clearly, but one company logo on the truck door was unmistakable. Pierce Development Group. Rachel watched the footage twice, then a third time without speaking. Finally, she looked toward me. They didn't discover the boundary by accident. They removed it on purpose. Before I could answer, Noah spread another set of county records across the table. I found something else. One parcel number appeared twice. 2 different maps. 2 different property descriptions. The same official county identification. Rachel's expression hardened. Duplicate parcel numbers. That doesn't happen by mistake. She flipped to the approval page. At the bottom sat one familiar signature. Victor Hale, Senior County Planning Administrator. For weeks I believed I was fighting an aggressive HOA. Now it was clear someone inside county government had helped make the fraud look official. If they were willing to erase a boundary from the ground, how much else had they erased on paper? Rachel wasted no time finding out. Within 48 hours, she filed preservation demands with the County Planning Office, the Recorder's Office, Pierce Development Group, Silver Pines HOA, and the bank financing the resort. Every letter carried the same warning. The ownership dispute had expanded beyond a civil disagreement and now involved evidence that could affect the validity of every recorded document tied to Redstone Island. No one stopped construction. If anything, it accelerated. When I drove past the lake a week later, framing crews were already raising roofs on the second row of cabins. Stonemasons worked along the shoreline, while electricians pulled cable through freshly buried conduit. What had once been open pine forest now looked like an expensive vacation destination. Denise wasn't slowing down. She was racing. Rachel noticed it too. They're spending money faster than they can justify. What does that tell you? Someone needs this project finished before the paperwork falls apart. The next Saturday, Silver Pines hosted a public open house. Large banners advertised luxury waterfront living. Golf carts carried prospective buyers through streets that hadn't even been paved a month earlier. I parked legally along the county road across the lake and watched through a camera lens. Denise stood beside a scale model of the completed resort. "Our first 30 cabins are nearly sold out," she announced. "Property values have already increased." Applause followed. No one mentioned the lawsuit. No one mentioned the disputed shoreline. Logan Pierce personally greeted investors arriving from Denver and Salt Lake City. Several wore bank logos on their jackets. Rachel quietly photographed every vehicle. "They're bringing lenders." Why? Because lenders only visit when there's money at risk. That afternoon, she served another round of certified notices. One went to the construction lender, another to every investor whose name appeared in county financing records. Each notice included copies of NOAA's survey findings and informed them that construction continued despite credible evidence the land ownership was disputed. 3 days later, the first response arrived. Not from Denise, from the bank. Their attorney requested additional documentation. Rachel smiled. Good. Why is that good? Because now they can't say they were never warned. Meanwhile, Denise became increasingly aggressive. Security guards appeared at the causeway entrance. Temporary fencing became permanent steel gates. Bright red signs declared the island closed to unauthorized persons. One afternoon, while I photographed construction from a public fishing access, Denise walked over with 2 security officers behind her. "You certainly enjoy taking pictures. I enjoy keeping records. You know these photographs won't change ownership." "No. They'll help explain it." She laughed. "You still think one old deed beats approved county records? I think the truth usually survives paperwork." Her expression tightened. "For someone who claims to own an island, you spend an awful lot of time standing outside the gate. I'll stand outside today." I looked past her toward the cabins. "But someday you'll be explaining why you built them." She turned without answering. For the first time since this began, she looked irritated instead of confident. That evening, Rachel spread financial filings across her conference table. "They've borrowed far more than I expected." She circled several numbers. Construction loans, bridge financing, future reservation deposits. The entire project depends on continuous cash flow. What happens if that stops? She looked at me. They don't just lose cabins. They lose everything. That realization changed how I viewed the construction. Denise wasn't ignoring our legal notices because she believed she would win. She was ignoring them because stopping would expose something even more dangerous than losing the lawsuit. The next morning, another anonymous envelope appeared in Rachel's mailbox. No return address. Inside was a single photocopied spreadsheet showing unexplained transfers from Silver Pine's reserve account into a consulting company neither of us had ever heard of. At the bottom, someone had handwritten just 6 words. "Start with the assistant treasurer." Rachel read the note twice. Then she slid it across the table toward me. I think someone inside the HOA just blinked. If an insider was finally willing to talk, what secret had become too dangerous to keep hidden? Rachel arranged the meeting at a small diner 40 miles from Silver Pines. The woman who walked through the door looked exhausted before she even sat down. "Claire Benson," she said quietly. "Assistant treasurer." She kept glancing through the window as though she expected someone to follow her. Rachel slid a cup of coffee across the table. "You contacted us?" Claire nodded. "I should have done it months ago. What changed?" She took a slow breath. "They're lying to everyone." She opened a manila envelope and pushed several spreadsheets toward us. They told homeowners the special assessments were for shoreline improvements. I scanned the numbers. Instead of maintenance expenses, millions of dollars had been transferred into consulting fees, land development advances, and management contracts. Most of the payments ended at one company, Pierce Strategic Consulting. I looked at Rachel. "Logan Pierce." She nodded once. Claire continued. "That company has almost no employees, but it keeps receiving HOA money." Rachel asked the question neither of us could ignore. "Did Denise approve these transfers?" "Every single one." Claire reached into her purse and removed another folder. "This is why I finally called." Inside were copies of monthly reserve reports. Silver Pines had nearly emptied its emergency fund. Money meant for roads, utilities, and storm repairs had quietly financed cabin construction. "If homeowners find out," Claire whispered, "they'll sue the board." Rachel corrected her. "They'll do more than sue." Claire lowered her voice even further. "They couldn't stop building." "Why not?" "Because the loans required construction deadlines." She pointed to one financing agreement. If Phase 1 wasn't substantially complete by September, every loan could be called due immediately. Suddenly, everything Denise had done made sense. The rushed construction, the refusal to slow down, the aggressive marketing. She hadn't been building because she felt safe. She'd been building because she was trapped. Rachel looked at me. "They're racing the bank." Claire wasn't finished. "There's something else." She carefully unfolded a yellowed document that looked far older than anything else she'd brought. This came from old HOA storage. Across the top, faded typewriter letters read, "Recreational Access Agreement, 1978. Rachel studied the pages. "Where did you find this?" In a box marked obsolete records, the agreement discussed shoreline access, boat launches, and shared maintenance between neighboring properties. Everything sounded ordinary. Until Rachel reached the final page. She frowned. "This page isn't numbered the same." Claire nodded. "It was separated from the others." Rachel read the final paragraph aloud. "Nothing contained within this agreement shall transfer fee ownership of Redstone Island or its surrounding shoreline. Ownership shall remain exclusively with the recorded title holder and heirs." Silence settled over the booth. I read the paragraph again. Then again. For 6 months, Denise had publicly claimed the HOA had always owned the recreational shoreline. Yet decades earlier, the HOA itself had signed an agreement admitting exactly the opposite. Rachel looked up. "Has Denise seen this page?" Claire hesitated. "I don't think so." "What makes you say that?" "Because every copy the board uses," she swallowed hard, "ends one page earlier." Rachel carefully placed the agreement into an evidence folder. "This changes everything." Claire shook her head. "No. It explains everything." She leaned closer. "The cabins were never the real project." "What do you mean?" "The island became collateral. The board needed valuable waterfront property to justify loans large enough to cover money that had already disappeared. In other words, the resort wasn't simply a luxury development. It was the cover keeping an enormous financial collapse hidden. Without the island, the entire structure unraveled. As Claire prepared to leave, she stopped beside our table. "If Denise learns I gave you those records, you'll have legal protection," Rachel assured her. Claire managed a weak smile. "I hope that's enough." After she walked away, Rachel immediately called Noah. Then she contacted a forensic accountant. Finally, she turned toward me. "We're no longer proving they stole your land." "What are we proving?" "That they built an entire resort to keep homeowners from discovering they'd already lost their money." As we gathered the files, my phone buzzed with a news alert. Silver Pines had announced that all 30 cabins were officially sold out. Investors were celebrating. Homeowners believed the project had saved their community. Only 4 people knew the truth. And somewhere, hidden long before any of this began, there still had to be the one document that could end every argument forever. The original deed. Rachel didn't waste a day. She built a timeline stretching back 70 years, tracing every recorded transfer of Callaway Island. Every deed matched. Every probate filing matched. Every tax payment matched. Except for one gap. "My grandfather transferred ownership to my father after my grandmother passed," I said, pointing to the chart. Rachel nodded. "The county has the transfer, but not the original deed that established title. It should still exist somewhere." That evening, I searched every filing cabinet in my ranch house. My father's study had remained almost untouched since his funeral. Old survey books filled one shelf. County tax receipts occupied another. Every drawer contained neatly labeled folders. Nothing. I found copies, certified copies, insurance policies, property tax statements, but not the original. Frustrated, I sat in my father's old leather chair, staring across the room. Then I noticed something I hadn't thought about in years. His framed photograph from the opening day of First Mountain Regional Bank. He had served on its advisory board for nearly 20 years. A memory surfaced. When I was a teenager, he'd once said, "Some papers are too important for the house." The next morning, Rachel and I drove straight to the bank. The branch manager, Margaret Ellis, welcomed us into a private office after confirming my identification. "You mentioned your father, Samuel Callaway." "Yes. He passed 8 years ago." She searched several archived records before looking back up. There was one safe deposit box. My pulse quickened. It was never closed. Rachel leaned forward. "Who has access?" Margaret smiled slightly. "According to these records, you do." An hour later, the vault door swung open. Margaret carried out a long steel box and placed it on the table. "This has remained untouched since your father's estate was settled." She left the room. For several seconds, neither Rachel nor I moved. Finally, I unlocked the box. Inside lay a bundle wrapped in brown waxed paper. The handwriting across the front stopped me cold. "For the next Callaway who has to prove the truth." Dad's handwriting. I carefully unfolded the package. The first document was thicker than modern paper, its raised county seal still visible despite its age. Original warranty deed. Recorded June 14, 1954, granting ownership of the entire island, including every foot of shoreline. Rachel immediately compared it with the copies we'd been using. "They're identical." "No." She pointed farther down the page. "They're not." Attached behind the deed was the complete legal description. Unlike every modern county copy, this version included the shoreline bearings referenced by the original iron monuments Noah had located. It also carried survey sketches signed by the county surveyor himself. There was more. Original probate records, handwritten boundary notes, the first title insurance policy. Correspondence between the county and my grandfather, confirming that the island's shoreline could never be subdivided without the owner's written consent. Then Rachel found a sealed envelope clipped to the back. Inside was a letter from my father. If you're reading this, someone has probably confused paperwork with ownership. Never argue louder. Bring better records. The land doesn't forget where its boundaries are. People do. For the first time in months, I smiled. Rachel didn't. She was already organizing the documents by evidentiary value. This isn't just an original deed. What is it? It's an uninterrupted chain of title. She began making a list. Original deed, continuous ownership, historical surveys, probate transfers, title insurance, county correspondence. No defense attorney wants to see this. That afternoon, she immediately arranged forensic examination. 3 document specialists confirmed the paper, ink, seals, and signatures all matched historical county records. At the same time, handwriting experts examined the deed Denise relied upon. Their preliminary report arrived 2 days later. Copied signatures, mismatched ink. Notary stamp issued years after the supposed signing date. One witness had died before the document was allegedly executed. Rachel looked up from the report. They didn't just fabricate ownership, they fabricated history. That evening, she filed supplemental evidence with the court and served copies on every attorney involved. Less than an hour later, Denise's legal team requested an emergency postponement. Judge Whitmore denied it. The trial would begin as scheduled. For the first time since the bulldozers crossed my causeway, Denise wasn't controlling the timeline anymore. She was reacting to it. But as Rachel packed the evidence into secure archival cases, she quietly reminded me of something. Winning ownership is only the first battle. I looked toward the photographs of 30 completed cabins sitting on her conference table. If the judge restores your land, he'll still have to decide who owns everything built on it. Rachel closed the evidence case with a firm click. That's tomorrow's fight. The first one starts in the morning. Rain tapped against the courthouse windows as we walked through security the next day. Denise arrived surrounded by attorneys, Logan Pierce at her side, both trying to project the same confidence they'd worn for months. But confidence looked different now. It was quieter. Forced. Judge Harold Whitmore entered precisely at 9. This court will hear evidence regarding ownership of Redstone Island. Rachel stood first. Your Honor, the plaintiff intends to establish 3 facts. First, Mr. Calloway never transferred ownership. Second, county records were altered. Third, the defendants continued construction after receiving repeated legal notice that ownership was disputed. The judge nodded. Proceed. Our first witness was Noah Whitaker. He placed enlarged survey maps before the court and carefully explained how original monuments established property boundaries decades before Silver Pines existed. Denise's attorney rose for cross-examination. Mr. Whitaker, isn't it possible those monuments were moved over time? No. Why not? Because 3 independent monuments match the original bearings within fractions of an inch. He pointed toward an enlarged aerial photograph. The only monument missing is the one beneath the defendant's construction. Rachel played the trail camera footage. The courtroom watched pickup trucks stop beside the missing boundary marker weeks before construction began. Workers dug, lifted something heavy, loaded it into a truck belonging to Pierce Development Group. Logan looked down at the table. For the first time, he stopped making notes. Next came Deputy Aaron Blake. He testified calmly. When I responded to the initial dispute, I informed both parties that ownership required a civil determination. Rachel handed him certified notices. Did you later observe these being served? Yes. Were the defendants aware ownership remained disputed? They were. So construction continued after formal notice? Yes. Denise's attorney objected. Calls for a legal conclusion. Sustained. Rachel nodded. No further questions. Then Claire Benson took the stand. She looked nervous until Judge Whitmore reminded her she was under oath and protected from retaliation. Rachel displayed reserve account records on the courtroom monitors. Ms. Benson, who approved these transfers? Denise Holloway. And these consulting payments? Also Denise. What company received most of the funds? Pierce Strategic Consulting. Logan slowly closed his eyes. Rachel produced the 1978 Recreation Agreement. Please read the final paragraph. Claire's voice echoed through the courtroom. Nothing contained within this agreement shall transfer fee ownership of Redstone Island or its surrounding shoreline. Ownership shall remain exclusively with the recorded title holder and heirs. The room fell silent. Judge Whitmore looked toward Denise. Has your board relied upon this agreement? Her attorney answered instead. Only portions of it. Rachel immediately held up 2 copies. One complete. One missing the final page. The defendant's version ends here. She tapped the incomplete document. The original continues. No one offered an explanation. Finally, Rachel called me. I carried the old survey tube to the witness stand. One by one, the original deed, probate records, title insurance, and chain of title entered evidence, each authenticated by forensic examiners, each predating every document relied upon by Silver Pines. Rachel asked one final question. Mr. Calloway, did you ever sign away ownership of your island? Never. Did anyone in your family? No. Did you ever authorize construction? I repeatedly warned them to stop. Rachel sat down. Denise's attorney stood for cross-examination. Mr. Calloway, if you believed you owned the island, why didn't you physically stop construction? I looked directly at him. Because Rachel Monroe told me something I'll never forget. What was that? She said evidence wins property disputes, not arguments. I paused. So I documented every warning instead. Judge Whitmore removed his glasses and spent several minutes reviewing exhibits without speaking. When he finally looked up, the tone of the courtroom had changed completely. This was no longer a dispute between a homeowner and an HOA. It had become a case about forged documents, missing records, ignored warnings, and deliberate choices. The judge addressed Denise's counsel. Based on the evidence presented thus far, this court has serious concerns regarding the authenticity of several county filings. No one on the defense table responded. The confidence that had filled the courtroom that morning was gone. Yet one enormous question still remained unanswered. Even if every deed Denise relied upon collapsed, what would happen to the 30 completed cabins already standing on my land? That question became the entire focus of the second day of trial. Judge Harold Whitmore looked over the packed courtroom before speaking. The court has heard substantial evidence regarding title. He paused. Now we address the improvements. Every contractor, lender, investor, and homeowner seemed to lean forward at once. Rachel remained calm. Denise did not. Her attorney stood first. Your Honor, regardless of any title dispute, our clients invested nearly $30 million constructing a completed resort. He gestured toward enlarged photographs of the cabins. Demolition would be economically reckless. Rachel didn't object. Instead, she quietly slid another binder toward the judge. Your Honor, we'd like to admit Exhibit 143. Inside were certified mail receipts. Every legal warning Rachel had sent over the previous 6 months, one after another. Construction company, development firm, Silver Pines HOA, primary lender, engineering consultants, insurance carrier. Each receipt bore a delivery confirmation. Each letter carried the same warning. Ownership remains disputed. Continued construction is undertaken at your own legal risk. Judge Whitmore examined several receipts before looking toward Denise. Were these notices received? Her attorney hesitated. Yes, Your Honor. Were they ignored? They were disputed. That wasn't my question. Silence answered him. Rachel rose. The defendants were never surprised by this lawsuit. They were warned before foundations were poured, warned before cabins were framed, warned before reservations were sold. They made a calculated business decision to continue. She turned toward the courtroom display. No one forced them to spend another dollar. Logan Pierce finally spoke. We believed we'd prevail. Rachel nodded. I believe you did. She walked closer. But belief doesn't transfer ownership. Logan had no reply. The court then heard testimony from a construction valuation expert. He confirmed that every cabin, dock, utility trench, and roadway had become permanently attached to the land. Removing them would destroy much of their value. Judge Whitmore asked the obvious question. So these structures cannot realistically be separated from the property itself? Not without enormous economic loss. The judge wrote several notes. Then he looked toward me. Mr. Calloway. Yes, Your Honor. If title is restored to you, what remedy are you requesting? Every eye in the courtroom shifted toward me. This was the moment Denise had counted on for months. She expected me to demand demolition. She expected me to appear vindictive. Instead, I answered honestly. I requested one thing from the beginning. My land. I'm not asking the court to punish anyone beyond what the law requires. I'm asking the court to recognize ownership. A quiet murmur spread through the gallery. Rachel said nothing. She already knew my answer. Judge Whitmore turned toward Denise. Ms. Holloway. For the first time during the entire trial, Denise stood without confidence. She looked toward the photographs of the completed resort before speaking. We acted in good faith. Rachel immediately approached the witness stand. May I? The judge nodded. She placed one exhibit in front of Denise, an internal email dated 4 months earlier. Rachel read aloud. Even if Calloway sues, keep building. Finished cabins will pressure any judge into protecting the investment. She placed another email beside it. Delay only helps him. Concrete creates leverage. Then a third. Ignore Monroe's letters. Once buyers move in, no court will unwind this project. Rachel stepped back. Were those your emails? Denise stared at the documents. Yes. The courtroom fell completely silent. Those 3 admissions changed everything. This had never been good faith reliance on county records. It had been a deliberate strategy. Build first, argue later. Hope the cost of undoing the project became too great. Judge Whitmore removed his glasses and addressed the courtroom. The evidence demonstrates that construction continued with full knowledge of a substantial ownership dispute. He paused. The defendants knowingly assumed that risk. Then he issued the ruling everyone had waited months to hear. The purported transfers of Redstone Island are declared void. The duplicate parcel records are invalid. Fee title to Redstone Island, including its shoreline, is restored exclusively to Ethan Calloway. A gasp rippled across the gallery. Logan lowered his head into his hands. Claire quietly closed her eyes in relief. Deputy Blake simply nodded. But Judge Whitmore wasn't finished. The question of ownership has been resolved. He closed the title file. The question of remedies concerning the permanent improvements will be decided at a separate damages hearing. His gavel struck once. Court recessed. As people slowly filed from the courtroom, Denise remained frozen in her chair. For months, she had believed every cabin increased her bargaining power. Only now did she understand the opposite. Every warning she ignored, every foundation she poured, every roof she finished, had strengthened someone else's property. Tomorrow, the court would decide whether she had built a luxury resort or handed it to the man she'd tried to erase. The damages hearing lasted less than 3 hours. Unlike the title trial, no one argued over who owned Redstone Island anymore. That question had already been answered. Now every lawyer in the courtroom focused on one issue. What should happen to 30 completed cabins permanently attached to land that had never belonged to the people who built them? Judge Harold Whitmore opened the hearing without ceremony. The court has already determined ownership. What remains is the appropriate equitable remedy. Denise's attorney rose first. Your Honor, if the improvements cannot remain under our client's control, we request compensation for construction costs. Rachel stood before he had fully returned to his seat. The defendants knowingly continued construction after repeated legal notice. She held up the familiar stack of certified mail receipts. They assumed that risk voluntarily. Judge Whitmore nodded. The record reflects as much. Logan Pierce made one final attempt. We created something valuable. No one disputes that, the judge replied. The question is whether you had the legal right to build it. Silence answered him. The court-appointed property expert testified that removing the cabins would leave the island scarred for years and destroy millions of dollars in usable improvements. The judge folded his hands. There are 3 possible remedies. He counted them carefully. Demolition, forced purchase, or the improvements become permanent fixtures belonging to the lawful owner of the land. The room became perfectly still. Judge Whitmore looked directly at me. Mr. Calloway, which remedy do you request? Rachel had prepared arguments for every possibility. I used none of them. I don't want 30 cabins destroyed. The judge waited. My wife, Rebecca, spent years dreaming about helping veterans find a quiet place to heal. I glanced toward the photographs of the completed resort. She believed this island should give people peace. I won't honor her by tearing it apart. Denise slowly looked up. For the first time since this case began, there was no anger in her expression, only disbelief. Judge Whitmore began reading from his written order. The defendants knowingly constructed permanent improvements upon land they did not own. They continued after repeated legal notice. Equity does not reward calculated risk undertaken in disregard of another's property rights. He signed the final page. The court therefore declares all permanent improvements, including cabins, docks, utilities, and related structures, fixtures appurtenant to Redstone Island. They are the lawful property of Ethan Calloway. The gavel struck once, just like that. 30 luxury cabins changed owners. No applause followed, only silence. The kind that settles over a room when everyone realizes history has changed. Outside the courthouse, reporters rushed toward us. One shouted the question everyone wanted answered. Mr. Calloway, what are you going to do with the resort? I smiled for the first time in months. It was never my resort. It was my land. And now I'll use it the way it always should have been used. Over the following months, the criminal investigations moved quickly. Victor Hale resigned from the county planning office before charges involving falsified public records were filed. Logan Pierce's development company entered bankruptcy after lenders withdrew support. Denise Holloway stepped down as HOA president and later faced civil judgments tied to the fraudulent transactions and breach of fiduciary duty. Claire Benson remained with Silver Pines long enough to help forensic accountants rebuild the HOA's financial records. Homeowners elected an entirely new board. The association rewrote its bylaws, requiring independent oversight for major land acquisitions and financial decisions. No one wanted another Denise Holloway. As for the island, we kept only a handful of cabins available for public rental. Their income funded maintenance and scholarships. The rest became quiet retreats for veterans, first responders, and military families needing a place to recover, reflect, and reconnect. On the entrance road, I replaced the sign that had been torn down months earlier. It no longer read Callaway Island. Instead, it carried a new name, Rebecca's Shore. Beneath it, a smaller plaque read, Truth Outlasts Greed. Sometimes I still walk to the old fishing dock we rebuilt where the first one once stood. Across the calm water, it's almost impossible to imagine the months of arguments, forged papers, and courtroom battles that nearly stole everything my family had protected for generations. Concrete can change a landscape. Money can buy machinery. Power can even rewrite public records for a while. But none of those things can move a boundary that was never yours to cross. In the end, Denise Holloway didn't lose because I shouted louder. She lost because every lie she built stood on land that had always remembered the truth.
If there's one lesson I hope stay with you, is this when something truly matters, your home, your family land, or your good name, patience can be just as powerful as determination. Ethan never tried to outshout anyone or take matter into his own hands. He kept records, followed the law, and trusted that facts would eventually speak louder than assumption. That didn't make the journey easy, but it made the outcome something he could live with. In the end, the goal wasn't to defeat someone else, it was to protect something worth preserving and to honor the promise he has made to his family. That's one of the things I love about stories like this. They remind us that dignity isn't measured by how loudly we respond when we challenge. It's measured by how firmly we stand, how honestly we act, and how faithfully we protect what is rightfully ours without losing ourselves along the way. Now, I'd love to hear from you. If you believe Ethan handled this the right way, type yes in the comments. And if you ever deal with an HOA, a property dispute, or a situation where keeping your cool make all the difference, share your story below. I read as many comments as I can, and your experience often inspire future videos. If you enjoy a story about standing your ground with patience, common sense, and respect for the law, I'd be honored to have you subscribe and join us for the next one. Until then, take care of yourself, and thanks for spending your time with me today.